Good afternoon, everyone. Welcome to another question and answer session live. My name is Samara Belitzky. I'm an employment lawyer at Samfiru, Tumarkin, and I work out of our Ottawa office. And I'm here, as I am several Fridays in each month, to answer all of your questions about employment law, workplace issues, severance, terminations, harassment in the workplace, you name it, I'm here to answer it, whether it's something you've been thinking about or maybe a family member or a friend is going through a difficult time, whatever the case may be. I'm here for the next half hour, so send in your questions. Happy to answer all of your questions. A lot of questions still about COVID-related issues, vaccinations in the workplace, and the most recent kind of trendy topic that we've been dealing with, of course, is returning to work, returning to the workplace after having worked remotely for so long. It seems like so many companies and employers are now mandating a return to work in some capacity. Starting in September, we've seen a lot of that. Some employers have gone, full remote or hybrid, but for those who haven't, we've seen some sort of return to form, some sort of return to work from a lot of people, and navigating those issues and what you can do as an employee, what you can do as an employer. That seems to be a very, very popular topic these days for obvious reasons. So if you are dealing with an issue like that regarding return to work, happy to answer those questions, happy to help you navigate through that. Definitely not an easy thing to be doing after 2 years or 2+ years working remotely, having to go back to work and adjust and figure all that out. So certainly there are legal issues that you have to navigate when doing that. One thing that I wanted to talk about specifically is with respect to, we talked about this a couple of weeks ago, but quiet quitting, which we've seen all over the news. It's become a big phenomenon. It seems to be this trendy topic, very clickbait, titles and articles online. But essentially, I wanted to address it because we're still getting questions about it. What that means is a situation where an employee is not going above and beyond their regular duties or their regular hours, and is just doing basically what you're supposed to be doing, nothing less, nothing more. And so I wanted to clarify that that's not necessarily a new concept. As an employee, you don't have to go above and beyond. You don't have to agree to additional duties or changes that you didn't initially sign up for. But you do have to be careful, because I did explain this a couple weeks ago, but again, it bears repeating. You need to make sure not to create a precedent as an employee. If you've taken on extra duties, if you've agreed to additional or different hours, and this has gone on for quite some time, many, many weeks, especially many months, even years, that means you've accepted those changes as part of the terms and conditions of your employment, and you cannot go back. You can't all of a sudden now refuse to do something that you've been doing for quite some time and that a precedent has been set for. So you have to be very, very careful as an employee. If you do want to refuse something that's being asked of you that you don't have to agree to, you have to act quickly in terms of refusing that. You need to express it, better to do it in writing, and you need to be clear that you're not accepting that. If, let's say, your employer wants to force certain changes on you, well, then there are ways of dealing with that, and we help people through those issues all of the time. If an employer is going to make a permanent and significant change to the terms and conditions of your employment, you don't have to accept that. You can assert what's called a constructive dismissal claim, meaning you can treat it like a termination of your employment, and you can go after your severance. Now, it's important to note that not every change will be a constructive dismissal, will be something that you can refuse as an employee. There are some minimal changes here and there that an employer can implement without your consent. But generally speaking, when we're talking about significant changes to your pay, to your hours, to your job, to your place of work, those are the more significant areas of the terms and conditions of your employment. And you certainly would have the right in many situations to refuse, treat it like a termination, and go after your severance. So again, when we're talking about this kind of phenomenon or seeming phenomenon of quiet quitting, it's really important to keep in mind it raises a lot of very important legal issues that if you are going through a situation where you're being asked to do something that you didn't sign up for as an employee, you have to deal with it at the time. If you keep working under the changed terms and conditions of employment, you will be deemed to have accepted those changes. and you won't be able to do anything about it moving forward. So it's really, really important if you're in a situation like that to get legal advice from an employment lawyer right away so that you make sure you're in the strongest position possible moving forward and you don't end up stuck in a situation that is no good. So anytime you're in a situation like that, definitely get in touch with us. You can contact us. We have our phone number. You can go to our website at employmentlawyer.ca. My contact information is there. All of our contact information is there. And you can contact us so that we can go through the situation with you, advise you accordingly, and help you through the situation. If it ends up being a situation where the employer is going to force significant changes on you, as I said before, we can certainly assist you with that. You can treat it like a termination. We can help you go after your severance. But always, always get the legal advice first. Don't just accept it until something happens, maybe months down the road, and then there's nothing you can do about it at that time. So I had a couple other things I wanted to talk about, just questions that I've been getting a lot this week. But I see that I have a bunch of questions coming in here. So send in your questions. Please keep them coming in. I'm going to get to them now. I'm going to start going through them. If we have time to get to the other topics by the end of this, I will go back and talk about some other important issues that have come up this week. But I would actually much rather answer your questions. So send your questions in. Anything that's been on your mind regarding employment law or workplace issues, send them in and we'll get to as many as we possibly can. So I have a question from Frank on Facebook who says, today I got a call from my son's school, had to go pick him up, and my boss told me, don't think about leaving, so I had to call my husband to go. Okay, so generally speaking, in terms of, what I think you haven't asked a question, Frank, but I can imply from what you've said, your question is probably, can your employer do that? Can they refuse to allow you to go? Now, when it comes to having to care for children, there is a provision under the Ontario Human Rights Code. It's under all of the human rights codes in the country, actually, with respect to family status. So there are certain protections that are afforded to you as a result of having a family as a family status provision. So what that means is if you have to care for your child, you're not allowed to be treated in a negative way because of it. You can't be treated differently because of your family status. And furthermore, if let's say your family status requires you to be accommodated in your employment, your employer would have to accommodate you. Now, the way that we saw this come out a lot during the pandemic was with respect to all of the daycares being closed and people having to, take care of their children during the workday because maybe you had no other family or no other neighbors or friends who could do it. And that's where we saw this obligation to accommodate come up a lot. It's really important to understand that while the employer does have an obligation to accommodate family status and childcare obligations, it's only to a certain extent, and it's only if all other options are exhausted. So if you've exhausted all other options with respect to childcare, and the only person who can care for your child is you, then your employer would have to accommodate you, but they certainly can ask questions and they can ask you to essentially explain to them or indicate that you've exhausted all other options before requesting the accommodation. Now, for childcare obligations that spanned, like I said, the pandemic where daycares weren't open, those were more burdensome in terms of accommodations on the employer's end. What you're describing, Frank, where your son is sick and needs to be picked up from school, that's a one-time, one-off, very quick thing that an employer would have to accommodate, again, as long as there's no other option. So if it's between you and your husband, then one of you will have to go. And if one of you can't go and you're it, then the employer would have to allow you to go. Maybe they want you to make up the time. It would be, a lot of employers can say, if you're going to go, that's fine, but I'm docking, 2 hours from your pay. That's fine. They're allowed to do that, but they do have to let you go as long as you're the only one that can go. So in your case, it sounds like your husband was able to go. You haven't necessarily exhausted all the options from a purely legal perspective, but it sounds like you didn't even have that conversation with your boss. It was just a blanket denial. So in the future, if let's say your husband can't go, you're the only one who can go, and this happens again, as it does, frequently children need to be picked up very suddenly. If that happens, be aware that as long as you have no other option, you're the one who has to go. You can insist to your employer that you have to go and get your child. Hopefully it doesn't come to that. I'm talking from a purely legal perspective and how the law works and what it says. But from a practical perspective, most employers would not have a problem with this, would not have an issue with this. Most employers understand that things come up with children where you have to suddenly go pick somebody up. And usually it can be discussed and worked around so that a mutual arrangement can be decided on between the employer and the employee. So if you're in a situation like this, on a one-off, obviously nothing you can do about it now, but moving forward, at least you know what the law says on this issue. If you're somebody, for example, who has a child who's chronically ill and this becomes a reoccurring issue, then it's something that you'll want to make sure you sit down with your employer to discuss. Have a conversation. Accommodation is a two-way street. It's a collaborative process. So if you know as a parent you're going to require continued accommodation because of a child's medical needs or what have you, have that conversation. Maybe get a medical note from a doctor. Have a conversation with your employer and make sure that they understand that this is a requirement that you're going to need moving forward. You're going to have to be accommodated for childcare and family status reasons. Again, it's protected by law as long as you've exhausted all other options. So I hope that's helpful. If anyone has more questions about that, it's a very complex topic and every single case is different. Every situation is different. That's why it's always important to get advice from an employment lawyer to make sure that you know where you stand and what the law says about your situation. I can't tell you how many people I've spoken to over the last couple of years during the pandemic. Like I said, when it was childcare obligations, daycares were closed, relatives were immunocompromised, so they couldn't watch the kids. This has happened over and over again, many times throughout the pandemic. There's always a solution. The law does provide for protections, and there's always a solution that can be found. You just sometimes have to get legal advice, sometimes get a lawyer involved to make sure that your rights are being protected. But at the end of the day, the law is there for a reason, and we're here to help make sure that if you require accommodation, you get it, period. So I'm moving now to a question from Veronica on Facebook who asks, is your boss obligated to fulfill a promise of a promotion if it was just a verbal agreement? Great question, one that we do get sometimes. In terms of there being any sort of promise of a promotion, it comes down to whether there was an agreement on something. So it really comes down to basic contract law, actually. And what it comes down to is, was there a meeting of the minds? Did you and your employer both agree on something? Was it supposed to be set in stone? Were the terms, all of the related terms of this potential promotion agreed upon? If so, there was a meeting of the minds, there was a contract that was formed, and there's an obligation that goes along with it. Most of the time for the situation you're talking about, Veronica, those things don't happen. There isn't necessarily a meeting of the minds. There isn't a discussion about the related terms associated with this agreement. It's simply a boss randomly or casually talking about a promotion that you might get, or saying you're likely going to get it, but it's not necessarily for sure or definitive. Maybe it's that they're telling you that they're going to consider you for a promotion. I've heard so many different stories like this where there's talk of it, but nothing ever comes to fruition. Unfortunately, if it's like those examples I just gave, where it's more of a discussion about it, you're told you're going to be considered, even if you're told you will get a promotion, but the details aren't discussed and nothing is discussed other than kind of a basic statement. Unfortunately, those are not things that you can hold your employer to. It needs to be an actual contract that's formed, usually in writing. It's always better in writing. If you're going to be offered a promotion, if you're going to be offered an improvement of some kind to your compensation or the terms of your employment, always important to get that in writing, because then you have actual written proof of it that you can hold your employer liable for and make sure they do what they say. If it's just a conversation, if they've just said it in passing, if it's not set in stone, unfortunately, you cannot hold them to it, and they don't have a legal obligation to carry out with that, that discussion or whatever it was that was discussed. If you have more details about what exactly was said and the context, feel free to send that in. I can look at it a bit further. You can also contact us directly to talk about this further. If you want to schedule a consultation with me or any of our other lawyers, we can go through this in detail with you and figure out exactly what your situation is, and if there is, if there was a contract formed, if your employer does have to comply with what you talked about, it will be different depending on those situations. So what's the context? What was said? What wasn't said? All of those things will matter in terms of assessing whether they have an obligation. But generally speaking, in the circumstances that I've mentioned, there wouldn't be one. And then again, if everything was kind of nailed down, set in stone, all the different terms were talked about, it was very clearly set out, there was a meeting of the minds between the employer and the employee, in that situation, there could be an obligation formed that you absolutely could hold your employer to. So it really does depend on the situation. But oftentimes employers will not be definitive enough in discussing promotions. And in terms of a reliance point of view, what can you rely on? You can rely on a written offer of employment. You can rely on a written employment agreement that outlines a promotion. You can rely on an email that outlines it. Those are all things that you can absolutely rely on and use to force your employer to carry through with what they said they were going to do. Otherwise, it would be extremely difficult. I have a question from Mohit on YouTube. If someone is working on a contract and the person wants to open a corporation and wants the employer to pay the HST or GST on the decided amount, but the employer refuses, what do you do? So if you're an employee, it's unclear to me based on this question, but if you're an actual employee, then you need to be paid as an employee, meaning it doesn't go through a corporation with HST or GST or sales tax on it. You're paid as an employee, it's income, and there are deductions made at source on your paycheck. That's the way by law that you have to be paid as an employee. If that's not what happens when you're an employee and you don't get paid as an employee, if you get paid as a contractor when you're an employee, for example, there's liability for you as the individual because you're not filing your taxes properly. There's also liability for the employer because they're not withholding the tax that they should. So if ever there was an audit, essentially the CRA would be coming after both parties. So it really benefits the employer and the employee both to make sure that if someone's an employee, they're being paid that way. If they're a contractor, they're being paid that way so that everything is consistent and the law is being complied with. So as an employee, you wouldn't have the ability to essentially force your employer to stop paying you like an employee and pay you like a contractor, which is what's being proposed in this scenario. If you're a contractor and you've always been paid like a contractor, then you already would be paid this way. You would be paid through a corporation or a business, and you would be charging sales tax on your services, on your invoice. So that would be the correct way to be paid as a contractor. So I hope that answers your question, but the way in which you're paid absolutely can carry risk if you're not paid properly. And I see this all the time when people come to see me after they've been let go. They think they're a contractor. They've been paid like a contractor this whole time while they've been employed. And it turns out, no, they're actually an employee. If you're actually an employee, then you have to be paid like an employee. You're owed severance, and you're owed everything else as a right and protection that would be owed to employees. So if you're in a situation where you're not sure if you're an employee or a contractor, it's always good to get a legal opinion on it. We can go through the situation with you, talk about, all the different factors in your work and give you an assessment of where you stand. Because oftentimes this issue comes up, I'd say mostly it comes up upon termination. Until then, there's not usually an issue because you're getting paid. You're able to file your taxes as an independent contractor, but there is always tax liability there. So you have to be very careful that if you're an employee, you get paid as an employee. And again, you are entitled to severance as an employee. Even if you sign a contract that says you're an independent contractor, it's not the contract that governs your relationship. It's not the contract that decides what status you are as a worker. It's the actual relationship. It's the actual working relationship. And what we look at is the degree of control. Does the business have a big degree of control over you as an individual? Do they get to dictate when you work, how you work, what you get paid for your work. These are all the different things that we look at, among other factors, in order to try and decide whether someone is an employee or a contractor. So it's really important to look at those things. It doesn't matter if you've signed something that says you're one way or the other. That's not what the courts look at. That's not what we look at. It's not a determining factor. So hopefully that's helpful. If that's not your situation, Mohit, feel free to contact us again. Feel free to email help@employmentlawyer.ca. You can also contact me directly if you have any follow-up questions for that. And I think just going off my last question, this is kind of on topic. I have a question from Cyber on YouTube who says, does a 17-year independent contractor have rights to severance if he's been paid on a monthly basis to be part of the organization and the company is their main source of income? So this is exactly what I was just talking about. You can be considered a quote unquote independent contractor for 17 years, be paid like a contractor once a month, through a company, get, pay sales tax, get, charge sales tax, pay sales tax. So maybe you've signed something that says you're an independent contractor. At the end of the day, those are not the things that determine what your status is as a worker. If you've worked for the same company for 17 years, especially if you've worked exclusively for that company, no other jobs, no other work, just for that company for 17 years, you're basically part of the team. They treat you like an employee. They tell you what to do. They dictate all the different various, facets of your work. You're an employee and you are owed severance. So it's not so much that you're owed severance because you're an independent contractor and you've been there 17 years. It's because you've been misclassified as an independent contractor when you're actually an employee, and employees are owed severance. There's also a third category that's between employee and independent contractor, which is called dependent contractor. A dependent contractor is also owed severance, just like an employee. The only difference is a dependent contractor doesn't work exclusively for one company. So if you've been with one company 17 years exclusive, like I just went through all those factors, you're an employee. If, let's say, you haven't been exclusively working for this company for 17 years, but it's been, like you said, the primary source of your income, over the years, it's been, 80 to 85% of your income each year is from this company. Maybe you have one side job where you get 20% to 15% of your annual income, but the vast majority is this company. Then you're dependent on this company to earn a living, and you're a dependent contractor. So you're still technically a contractor because you have multiple jobs, and there might be other elements at play here that would militate towards you being a contractor. But as long as the company has that degree of control over you and you're reliant on it for the vast majority of your income, you would likely be a dependent contractor and be owed severance. So you have those two possible categories where you would be owed severance: employee and dependent contractor. In the circumstances that you're describing here, Cyber, this absolutely sounds like you would be an employee, or at the very least, a dependent contractor. So if you are in a situation where you're being let go or you think you're going to be let go, definitely get in touch with me. I'm happy to go through the assessment of your severance entitlements with you. But given that you've been with the company for 17 years, you're going to be owed a significant amount of severance. So you certainly want to make sure that you're protecting yourself and pursuing what you're owed. I have a question from Archie on YouTube, who asks, should severance pay include a payout for any unused vacation days? So the way that it works with vacation is when you're being let go, any vacation that you've accrued up to your date of termination has to be paid out to you. And that's with respect to any end of employment. So even if you are resigning, if you quit your job or you're let go, no matter what, it's not part of any sort of severance package. This is just owed to you regardless of how your employment comes to an end. You're owed the vacation pay that you've accrued up to the date of termination. And again, it's what you haven't taken. So if, let's say, you're owed 3 weeks per year and you work for half the year, you're let go in the middle of the year, then you've accrued half of your vacation entitlements, meaning a week and a half. And if you haven't taken any vacation so far during that year, you're going to be paid out the full week and a half. If, let's say, you've taken a week so far that year, then you'll get half a week paid out to you as vacation pay. The other thing that's really important to keep in mind is when you are let go, specifically when you're let go. So if you resign, this is not part of what you're owed. It's only if you are let go. Like I said before, you're owed any vacation you accrued up to the date of termination, but you also have vacation that continues to accrue beyond your termination date for the minimum amount of weeks that you're owed under the Employment Standards Act. So under the Employment Standards Act, there's a minimum amount of weeks of notice or pay in lieu of notice, in other words, termination pay, that's owed when somebody's let go without cause. So for a regular termination, it goes all the way up to 8 weeks. So it's essentially about 1 week per year of service, up to 8 weeks once you hit 8 years of service. So depending on how many weeks you're owed under the Employment Standards Act, it can vary between 1 week up to 8 weeks. But your vacation will continue to accrue for that many weeks post-termination. So for example, if you're owed 3 weeks under the Employment Standards Act as your bare minimum, your starting off point for your termination entitlements, that would mean you have between 3 and 4 years of service. You're owed 3 weeks as your bare minimum. And so that means that for 3 weeks post-termination date, your vacation continues to accrue. So when you get paid out, you should get everything that was accrued up till your date of termination, and then whatever accrued for vacation pay in those weeks following your termination as well. Those are amounts that are owed no matter what. They're minimum amounts owed under the Employment Standards Act. They're non-negotiable. You don't have to sign anything to get those amounts. The employer has to do that as a bare minimum. That's your starting off point. And then from there, the rest of your severance can be negotiated when we're talking about your full severance. But that's just a bare minimum entitlement that everybody has when they're let go on a without cause basis, meaning a regular termination. Okay. We're getting to the end of this. I'm just seeing if we can get to a couple more questions. So Cyber, I see here, Cyber on YouTube, I see that you've sent a follow-up question here with some additional information. It sounds like you're on a fixed term contract that the employer or the company is just letting expire, and they've given you 60 days notice of the end. Definitely get in touch with me. This sounds like a situation where you're very likely an employee or a dependent contractor, and you will be owed severance much more than 60 days or 2 months. So please get in touch with me. You can go to our website at employmentlawyer.ca. On our website, all of our lawyers are listed. I have a listing there as well. Click on my picture, click on my name. You'll see my email address. Send me an email. More than happy to help you with this, because this is exactly the type of situation I was describing before, where it's very possible that this company is trying to take advantage of the fact that you've been misclassified for all these years and essentially let you go without giving you what you're supposed to get. So definitely get in touch with me. More than happy to help you with this, because you have to make sure that you're pursuing what you're owed here. Don't let the company get away with it. All right, so send me an email, and I'm more than happy to help you with that. Anyone else out there who's watching this, as I mentioned before, if you're not sure about the status of whether you're an employee or a contractor of any kind, definitely get in touch with us. We're more than happy to go through the situation with you, assess your case, and let you know where you stand. I cannot tell you how many people contact me saying, for all these years, I thought that I was a contractor. I didn't realize I was owed severance. They were just going to walk away and not get what they're owed. So it's really important to get in touch with us and make sure that you protect yourself moving forward. So we're just at the end of the session for today. Thank you everyone for your questions. I won't be able to take any more for today, but we do have other sessions next week, almost every day, if I'm not mistaken. So tune into those, and certainly we can answer all of your questions at that time. So again, thank you very much for joining us, and I hope that everyone has a wonderful weekend.